Anuprada, are you saying something? You're on mute.
No, I was saying something to someone else. So I'll just start to welcome everyone. Now I'll just introduce our speaker for today. Her name is Sharita Samuel. I'll just give a brief history of what she has done. She was part of the legal division of a commercial bank. Later on, she worked with Legal Resource Center from 1995 to 2009. She has worked on issues like family law, gender equality law from the constitutional perspective. She has also worked with South African Legal Assistance Network, where she trained people against discrimination, labor exploitation, women rights issues, and other issues. She has strong passion for public interest law, and she trains a lot of lawyers at LRC. So is Erica here? I would request her to take over for moderation. Is Erica here?
Yes, I'm here.
Thank you.
Hello, everyone. Can you hear me correctly?
Yes, we can.
Okay, wonderful. Well, it's a real pleasure for me to introduce Sharita Samuel to this audience. It is a pleasure to hear your remarks in a complex case regarding public policy in land distribution in order to face a dire economic situation of Black farmers in South Africa by providing infrastructure and resources to work the land. The case that Sharita will explain to you all has to do with economic, social, and cultural rights, social justice and development, and is intersected by discrimination and moreover, the lack of transparency and accountability of public funds. The LRC represented the Council for the Advancement of the South African Constitution, CASAC, in the case against the Public Protector. As Sharita will explain, the Public Protector is one of 6 independent state institutions set up by the country's constitution to support and defend democracy. It receives and investigates complaints from the public government. During 2012, the province of Free State in South Africa launched a provincial policy intervention, which was aimed at revitalizing the agricultural sector and revitalize the Brede community, specifically a dairy project, through job creation opportunities. At the end, as Sharita will tell us, but I will spoil the ending, the farmers were left with nothing and the public investment went to private hands and extraordinary corruption case. Sharita, I remind you that you have 1 hour for your presentation, and then we will open the discussion and take questions for the participants for 30 minutes. Thank you very much, and Sharita, you have the floor.
Thank you, Erica, and thank you for the invitation to present this lecture. And I look forward to future engagements on any common interests that we may identify going forward. So I think it's necessary to explain the context of the LRC as one of the oldest public interest law centers, which functions as a non-profit law clinic for strategic litigation and law reform for clients who suffer dispossession and injustices. So the LRC was founded in 1979 by Arthur Chaskalson, who went on to become the first Chief Justice of a newly democratic South Africa, Lady Felicia Kentridge and Jeff Butlinder. We operate from offices in Johannesburg, Cape Town, Durban, and Makanda. And for over 4 decades, the LRC has litigated human rights violations ranging from civil and political to socio-economic rights before the High Court, the Supreme Court of Appeal, and the Constitutional Court. Many of the LRC lawyers have gone on to become judges in a democratic South Africa and responsible for bold judgments. The LRC's path was difficult because prior to 1994, the mechanisms for public interest litigation were very limited. There was no Bill of Rights, there was complete parliamentary sovereignty and very strict prescription laws that favored the state and a very repressive apartheid political climate. But this also presented the opportunity for brave public interest lawyering to defend civil and political rights with a clear focus to take down apartheid laws and structures. Post-1994, the enactment of a constitution and a Bill of Rights, as well as the creation of a very liberal constitutional court, now supports effective public interest litigation because of generous standing provisions and with wide remedial powers. Post-1994 did create uncertainty amongst public interest organizations, and one of the main reasons for that was the older generation of public interest lawyers had moved into the civil service of the new democracy. And so this left the public interest law sector with fewer lawyers that were sufficiently versed in the new constitution. And some of them also held the belief that the new order, like all of us do actually, would do the right thing and that it needed to be given the space to do so rather than being antagonized by public interest litigation. Now, we all know that that did not come to pass. So today, the major challenges facing South Africa in its public interest litigation sector, like all over the world, includes the lack of funding, lack of experienced, skilled staff, and of course, the attitude of government. For me to provide a context as to why the LRC intervened in this matter, it's necessary for me to take you and to show you how South Africa moved from British colonialism to an official system of apartheid. And this occurred for a large part of the 20th century. With that system, the government, controlled by the minority white population, enforced segregation between government-defined races. And this extended to land ownership, housing, education, and all spheres of life. And it created three nations, one of whites. These were people primarily of British and Dutch ancestry, one for blacks, one for coloreds, and ethnic Asians. This ethnic separatism of the South African apartheid government was terminated, as you know, by the 1994 election of a government led by the black majority and under the leadership of the long imprisoned Nelson Mandela. And this date marked the transition for social equity of all races over the last 27 years. But as we all know, greater political equality does not translate into social tranquility. And South Africa remains entrenched in disparities in housing, particularly land ownership and educational opportunities, and very disparate basic infrastructure along racial lines. And this extends to transport, water, sanitation, and electricity. This is because the apartheid government determined racial and ethnic classification in the Population Registration Act. And this act determined the status of all South Africans under apartheid. And it was a very arbitrary classification system. For example, it was, in some cases, it was based on family background, physical appearance, and cultural acceptance. And it culminated in the Group Areas Act of 1950. And under the provisions of this act, South African cities acquired a characteristic. It was white residential areas, generally situated in more favorable localities, spatially pleasing or environmentally pleasing, and close to the city center, where all the amenities were at that stage. They occupied most of the urban spaces, while other sectors, blacks, the coloreds, and the Asians, were placed on the peripheral localities of such services and transport nodes, educational opportunities, or employment opportunities. This act was repealed in 1994, but the racially defined settlement patterns that had become entrenched during the system of apartheid still persist in our democracy. So South Africa's original constitution was the British Parliament's South Africa Act of 1909. And this united two former British colonies, the Cape of Good Hope and Natal, with two former Dutch colonies or Dutch republics, that was the Transvaal and the Orange Free State. And it was based on a parliamentary system with the British monarch as the head of South Africa. The subsequent Republic of South Africa Constitution Act of 1961 transformed the country from a dominion within the British Commonwealth into an independent republic that was tasked with implementing the apartheid policies of the white minority. The latest constitution, the 1996 constitution, which took effect in 1997, points to the injustices of South Africa's past. It highlights it and defines the republic as a sovereign democratic state that is founded for the achievement of equality and advancement of human rights and freedoms. And the common law of South Africa is based on Roman Dutch law. This is the uncodified law of the Netherlands, which was retained after the Cape's cession into the United Kingdom in 1815. The South African judiciary comprises of the Constitutional Court, with the powers to decide on the constitutionality of legislative and administrative actions, particularly with respect to the Bill of Rights. The Supreme Court of Appeal, which is the highest court of appeal except in constitutional matters, and the High Courts and the Magistrates' Courts. Now, the Supreme Court is headed by its president, who is appointed by the state president, as is the Chief Justice of the Constitutional Court. And other judges are appointed by the president, but on the advice of the Judicial Services Commission. And it's a highly critiqued and contentious process and mechanism. Now, as they are everywhere in the world, the patterns of daily life in South Africa are conditioned by our social class, our ethnicity, our religion, and our residence. For example, the life of a black diamond miner in Limpopo province is very different from that of an Indian shopkeeper in Durban, or an Afrikaner office worker in Johannesburg, or the teacher of English descent in the Western Cape. And as the government struggles to expand the economy to provide equally for all citizens, the great disparities persist and continue to tear us apart. And in order to protect this independence and to advance it and to promote it, Chapter 9 of the South African Constitution has introduced Chapter 9 institutions, which is a group that is established to guard democracy. And one of these offices, as Erica said, is the Office of the Public Protector. This office is required to be independent and subject only to the Constitution. Other organs of state are required to assist and protect this office. And they are also meant to ensure this office's independence and effectiveness. And as we will demonstrate by means of this case, that did not happen. The provincial government or the local government, or in fact the national government, did nothing to intervene in this project that the LRC had to eventually litigate. So Chapter 9 institutions have twofold roles. One is to check government, and the other is to also contribute to transformation. And they do this by being the link between government and the people on the ground. But they are not a branch of the government. They do not govern. They are intermediary institutions providing this link between the people and the executive and the parliament on the other. Now, their independence is very strongly asserted in the Constitution, And it does so by using language that is virtually identical to that used to declare the independence of the courts. But independence and impartiality cannot be created by declarations. As lawyers, as activists in the public interest sector, we know this. So located between citizens and the government, these offices, these Chapter 9 institutions and the Public Protector's Office are intended to provide a reliable voice for the people. They cannot be burdened by the vested political interests of the day. And unfortunately, as our litigation demonstrated, the Public Protector now faces allegations that her work was insufficiently independent due to the contentious report that she filed in the Freire Dairy project. Now, in order to understand why this Freire Dairy project is so significant and why it caused us to litigate it right up to the level of the Constitutional Court, we need to understand legislated land dispossession, forced removals, and the codification of laws that dictate the rhythms of our politics today. Some hold the view that the mechanisms of the Constitution not only allow for land reform, but in fact that it requires the political and legislative branches of our government to carry it out. Others, however, persist in questioning the legitimacy of the constitutional framework on land reform. The LRC holds that the Constitution is not a stumbling block to transformative land reform, but rather a key mechanism which demands that such change takes place. But the reality that we face in South Africa today is that the very establishment that seeks to portray the Constitution as an impediment to land reform is in fact responsible for the failure to change our historical patterns of land dispossession or land ownership. And as former President Nelson Mandela reminded us, Black land dispossession produced a white minority of barely 15% of the country's population that owned 87% of the land, whilst the Black majority, being the Africans, Coloureds, and Indians, occupied less than 13%. Now, these are staggering figures, and Mandela correctly noted that while whites owned land, Blacks could obviously only just occupy it. And the fundamental theme has remained consistent, that the more land and wealth that was ripped from the Black population, the more prosperous and secure the white population would feel. And this aligned with the priority to provide cheap labor for the benefit of the white population, and the apartheid project, which was to strip Black South Africans of their citizenship and to relegate them to undesirable land. Now, while the story of the physical dispossession of land and displacement is important, it becomes even harder to explain, as you know, the high cost of such dispossession, because this toll was not simply economic. Through forced removals and the outlawing of Black land ownership, a population was deprived not only of land, but also of places of ancestral significance. And this caveat is crucial to understanding the complexities of compensation, of reparations, and redistribution of land and resources, all the resources, the ocean resources, the land, and below the ground resources that we now confront. And we hope that someday it will be calculated, and this will then provide or direct specific goals for the objectives for land reform. But we are still working towards that. So this history makes land reform an imperative because of its socio-economic benefits and also the belief that a successful land reform program can promote crucial political stability and economic growth for the majority of South Africans. So the objective of redistributing land to a specific number of beneficiaries also becomes important, because for any land reform program to be effective, it should not replicate the structural inequalities of the past, but rather break them down, obviously. So if, for example, if 30% of the country's land was transferred from a small white elite to a small black elite, then the existing problems of inequitable land distribution would persist to haunt us. And the only thing that would change would be the race of the elite group who now held large holdings of land. So therefore, one of the pitfalls of vague objectives in land reform without these clear goals now makes it difficult for the people in our country to hold those responsible for land reform or the corruption in land reform accountable. Now, constitution blaming and arguing whether Section 25 is enabling or inhibiting reform reminds us that a simple constitutional amendment will do little to change the status quo. Any expropriation act must be accompanied by just redistribution laws and not mere policies. And these must be accompanied by clear beneficiary selection and compensation policies in support of such redistribution law. Now, the public interest litigation taken to the Constitutional Court over the last 15 years in land reform hopes to establish jurisprudence for this equitable redistribution. And we are striving for legal precedents similar to what the Constitutional Court has handed down, defending the rights to housing and preventing evictions in our country. So just to remind you that Section 25(2) of our Constitution states that property may be expropriated, but only in terms of law of general application, and it must be for the public good, in other words, for the public interest. And this public interest, for the purposes of Section 25, includes the nation's commitment to land reform and to reforms that bring about equitable access to all South Africa's natural resources. And land reform is protected from the rest of Section 25 in Section 25(8), which states that no section may impede the state from taking legislative and other measures to achieve land, water, and related reform in order to redress the results of past discrimination. Excuse me. Provided that any departure from the provisions of this section is in accordance with Section 36(1). And evidently, as we can see, the Constitution is clearly not an obstacle to state-led land reform. But what we are clearly beginning to see is the lack of political will, and failing that, if that will does not manifest as the people expect it to, then there will be no option but to challenge and attack the constitutional failures relating to land reform. By blaming the Constitution, the state is merely deflecting. It's deflecting from the record of its own corruption and state capture. And the damage wrought by this corrupt leadership in land reform feeds this controversy over land as a symbol, well, it remains a symbol of unresolved injustices, and it is now being exploited for political gain. It deflects from the failures and missteps of the government, but it also highlights that political liberation by default did not result in economic liberation. And it is this context that led to the LRC challenging the Public Protector's investigation into the irregularities and the corruption in one of the state's land redistribution projects. So in this case, we represented the Council for the Advancement of the South African Constitution, CASAC, and CASAC instructed the LRC to review and set aside this report and to obtain a declaratory order that the Public Protector had failed in her duty to investigate and report on the Vrede Dairy project. Openness, accountability, and transparency are essential. They are the cornerstones of any successful land redistribution project. And it becomes imperative because there are large amounts of money that is being used by the government towards assisting emerging farmers and communities. And the objective, of course, is for sustainable enterprise to break the cycle of poverty. So the money is intended for poor, vulnerable groups in our population. And so properly run redistribution projects and government support for such people gives substance to the state's goal for development. And any failure to observe or maintain proper monitoring and accountability systems leads to a pattern whereby the elite and politically connected unduly benefit from land redistribution, whilst the intended beneficiaries are left with unfulfilled dreams or unfulfilled expectations of equitable access to land. Now, these Chapter 9 institutions, such as the Public Protector, they exist, they were instituted, they are constitutionally bound to hold those who misuse public power accountable. But in this case, the Public Protector failed to do so. And the result was that obviously the intended beneficiaries were just a front and they received nothing. And several 100 million rands later, nobody knows where all of this money has disappeared to. So, yeah. Now, the Public Protector's report that was entitled Allegations of Maladministration Against the Free State Department of Agriculture was compiled in the face of immense numbers of reports of widespread corruption, maladministration, and impropriety. So it's not as though there was a lack of evidence or that there had been complete silence following the corruption of the project. Activist journalists and civil society organizations had documented what had transpired in the Vrede Dairy redistribution project. And that is why the failure of the Public Protector to actually investigate and report as required was so unacceptable. It was insulting to the beneficiaries and to the expectation of her as a Chapter 9 institution. And what it did was that it completely absolved the politically connected kingpins of any wrongdoing. So the background to this, as Erica mentioned, is that in 2012, the provincial government in the Free State launched an intervention, and it advertised it as a project that will revitalize the agricultural sector through investment. So like dollar signs are obviously ringing in people's ears. And the Vrede Dairy project was identified as one of the flagship projects that was intended to uplift that community. So residents in the area were told that hundreds of cows would be bought and distributed to farmers in the local township, and that they would each get a few cows and the milk from them would go to the dairy. And in April 2012, Estina Pty Limited, which presented itself falsely, it would turn out, as being a partnership as being in partnership with the company with technical expertise, submitted a business proposal for the establishment and management of this project. But in early 2012, the department appointed Estina without any procurement processes or systems being complied with no due diligence being performed, recorded, or documented in any way. And this dairy project became, well, very soon became mired in corruption and maladministration, and it delivered absolutely nothing to the farmers. The farmers did not even hear anything after the date on which their names and ID numbers and telephone numbers were written on a piece of paper to be used for the advertisement of this project. They had never been contacted by anybody after that. In 2017, hundreds of thousands of emails revealed that the company's corrupt business dealings with the South African state and its politicians, the famous Gupta leaks. And these emails corroborated the earlier 2013 reports that the Vrede Dairy project was mired in corruption. It illustrated the corrupt control exercised over the project and how millions of taxpayer rands was pilfered from the public purse, and how senior government officials were complicit in the theft and corruption of this money. And this was followed by complaints being lodged by the opposition political party, the Democratic Alliance. So one of the MPs filed a complaint with the Office of the Public Protector. And on assuming office in October 2016, this current public protector, Mekwabane, inherited the provisional report that was prepared by her predecessor, Madonsela. But in 2018, she quietly released her own version of the report, which merely highlighted some irregularities, gross negligence. But most tellingly, as remedial action, she recommended that the very state officials that now stand accused of that corruption must initiate and institute disciplinary action against the implicated lower officials in that government. And she also deviated significantly or in material ways from the provisional report that was compiled by her predecessor. She narrowed the findings or the ambit of those findings, and she omitted significant remedial steps that were proposed in that provisional report. And when this came to light in the media, CASAC then instructed the LRC to challenge that report on the basis that she had failed in her duties to investigate the complaints that were made against her, against the project and against that provincial government. So what we discovered during our process of due diligence is that she had ignored significant evidence of corruption that was already in the public domain. And she made a concerted effort to protect the high-profile politicians with this watered-down report. And therefore, it was clear that the Public Protector as a Chapter 9 institution had failed to fulfill her mandate of acting in the public interest. She failed to prescribe and implement an appropriate, proper, fitting, or effective remedy against corruption. In fact, the remedial action which she devised provided that people directly implicated in this corruption would oversee the discipline against the others that were also guilty of this corruption. So yes, of course, this caused great outrage. It is unacceptable that the beneficiary agreement that stated that the project would enhance the living conditions of poor people, dispossessed people in both rural and peri-urban communities through the establishment of a government-led project would actually lead to absolutely nothing in their hands, notwithstanding the large amounts of money that this project actually absorbed. So the project was, how do you say it, so bold, or departure from the project was so bold that they even went to the extent of depositing some of those cows to maintain a public facade and on random farms in the Free State. And it was this action actually that drew public attention to the corruption, because many of those cows actually died and they affected the rivers which provided the source of water to communities. And that is what alerted investigators of the fact that something was awry in this district, in this community, and in this province, and then in this project. So jobs in the rural areas are hard to come by in South Africa. We have very high unemployment statistics. And this project had promised many jobs in what is a very poor province. Excuse me. The fact that a community or communities in these very grave socio-economic circumstances were exploited and lied to and defrauded in this fashion created immense public, shall we say, outrage in South Africa. And the much publicized intention of the project to uplift the community and for the 80 direct beneficiaries to own 51% of the project, having that exposed as being a front used almost as bait to falsely advertise the project, when in reality it just served as yet another opportunity for corruption. So it almost begs the question, okay, so how is it in what is supposed to be an era of social media, of extreme information sharing, that this kind of action is actually allowed to proceed for almost 6 years? It was terrifying to the country. So the legal framework for this intervention was obviously the Public Protector Act and the Constitution. And obviously, flowing from that, the mandate, which is to strengthen the constitutional democracy of our country by acting with independence and impartiality. So it has to be beyond question. The actions, the investigation, and the remedies have to be beyond question. And the Constitutional Court has found that the purpose of the Public Protector's Office is to ensure that there is an effective public service which maintains a high standard of professional ethics. And in this project, or in this investigation, and in this report, the Public Protector displayed none of this integrity, none of these qualities. And to this end, with those expectations, the Public Protector is conferred the powers to investigate complaints of the public and to report on that conduct. And when such failure comes to our attention, then the public interest sector and civil society is duty bound. We are obliged to actually respond. So Section 7 of the Public Protector Act confers specific powers on the Public Protector to investigate fully, and her investigative mandate requires pro-action in appropriate circumstances. and her powers are of the widest ambit. It also, these wide powers allow the public protector to request other people in government or other departments in the government that perform a public function to conduct investigations for her under her supervision and control. So it is no excuse for the public protector to say that she had inadequate resources. She has wide powers to demand and to request the assistance that is needed for full investigation. The Supreme Court of Appeal has also held that the public protector has a proactive function, and he or she is not expected to sit and wait for evidence to fall into their laps. So it is, what can we say? That she is not expected to wait for proof whether there are allegations of corruption, but is actually mandated to actively discover the truth by using her wide powers and all the resources that are at her disposal by means of the Constitution and the Public Protector Act. And that is the reason why the LRC then took this report on review. It was because of our commitment to equitable access to land and our disquiet at the fact that poor and rural communities were used as a front for corruption in such a blatant manner, which was then exacerbated by a Chapter 9 institution, which is meant to listen to them, to go to them, interview them, and make sure that you actually represent their interests in an independent and objective manner. But none of that transpired in the public protector's process. And therefore, in May 2019, the LRC succeeded in obtaining a judgment from the Pretoria High Court with the following order. It was an order that declared that in investigating and reporting on the Vrede Dairy project for the purposes of her report, the public protector failed in her duties under Section 6 and 7 of the Public Protector Act and Section 182 of the Constitution. Her report was reviewed and set aside, and it was declared unlawful, unconstitutional, and invalid. And the public protector, in her official capacity, was ordered to pay 92.5% of CASAC's costs on an attorney and client scale and 7.5% of CASAC's costs, the LRC's client costs, in her personal capacity. And in its judgment, the court found that the report was too narrow and it appeared to ignore the issues raised by an earlier Treasury report, the media reports, and the complaints lodged. There appeared to be no logical or legitimate explanation for narrowing the scope of the investigation to such an extent that she in fact did not investigate. She did not investigate who the true beneficiaries of the project were, the role played by the government officials in pushing through these projects, or the impact on approximately 80 intended beneficiaries as advertised in all the media reports of this project. So the court found that despite having access to information on the beneficiaries' identity numbers, their addresses, their telephone numbers, the public protector made no effort to contact or speak with them. She did not speak to the beneficiaries, the people that were most affected by this fraudulent project. And the court held that the public protector's failure was irrational and ignored relevant considerations, and her proposed remedial action that the corruption implicated senior officials to act as arbitrators of lower ranking officials, scapegoated departmental employees against more higher ranking officials was not an appropriate or effective remedy. So the court in this case established the principle that the public protector does not have the option. She does not have the option of opting out and deciding not to investigate when complaints fall within her jurisdiction. The Constitution and the Public Protector Act make it clear that her wide powers to investigate is coupled with the duty to exercise that power. She has to demonstrate that she is exercising that power, and she failed to do so in the Feder Dairy matter. And in particular, the public protector cannot be selective in the cases that she chooses to investigate. And she also cannot be subject to pressure by any person not to investigate a complaint. And this ensures that complaints relating to abuses of such public power and such corruption are investigated, exposed, and remedied. So while she has this power to take this remedial action, she has a duty to exercise it for whatever complaint and against whoever the public protector is called upon to investigate. Now, under Section 7.3, the public protector can also call upon any such person in government to assist her with the performance of her functions. She failed to do this. She can actually subpoena the records, and she can also subpoena such officials to present her with evidence, or the bank accounts, or the bank statements of the parties that she suspects of any maladministration or corruption. And by failing to do any of this, the court held that she had failed to comply with Section 6 of the Public Protector Act. And she contravened Section 6.4a and 6.5 of that Act, and Section 182.1a of our Constitution. These were manifest failures. They were totally unacceptable. So not only did we have the corruption that was perpetrated in the redistribution project, but it was compounded by the gross failure of the public protector to, well, not even remedy, but to at least investigate and report on it impartially. So in establishing whether a public functionary such as the public protector can use the defense of budgetary constraints, which she did, and which thereby precluded from fulfilling its constitutional obligations, the court follows the Constitutional Court judgment in cases where the court adopted a context-sensitive, reasonable standard. A functionary is required to show that he or she has taken all reasonable measures within his or her available resources to fulfill the constitutional obligations. And it was found in this case that the public protector did not adequately set out supporting facts to illustrate why a proper investigation could not be accomplished or carried out or finalized by her. And in any event, the Treasury's report and the provisional report by her predecessor, for which much work and investigation had already been conducted, could have been used by the public protector to limit the expense or the time to complete her investigation properly and adequately. So, Erica, I'm not sure whether I still have more time. May I go into further detail, or is my time running short?
Sharita, you have 14 minutes left.
40?
No, 14.
Ah, all right. Okay, then I will do a very good and concise conclusion to my lecture. And I think it is necessary for me to say that in the provisional report compiled under the current public protector's predecessor, Thuli Madonsela, one of the remedial actions stipulated was to refer the matter for further investigation by the Special Investigating Unit to conduct forensic investigations into serious maladministration and unlawful expenditure, and also to the Auditor General to conduct a forensic and due diligence audit verifying the expenditure of public money. In the final report that the LRC reviewed, this remedial action was removed. And the public protector stated that she had removed this remedial action because she considered that she did not have the power to instruct the Special Investigating Unit or the Auditor General to investigate on her behalf. The court confirmed that the public protector's view was inaccurate. The public protector holds the legal power to instruct both the SIU or the Auditor General, and Section 6(4)(c) of the Public Protector Act expressly empowers the public protector to at any time prior to or during any investigation refer the matter to an appropriate public body or authority to make an appropriate recommendation. So I think the nature of the defenses that were raised and the degree of dishonesty that embedded the process of her investigation highlight the brazen tactics or the brazen steps that are sometimes indulged in order to frustrate equitable access to land or equitable land reform in our country. So I think something must be said about the fact of how LRC worked with CASAC, which was an institutional client. And CASAC is a voluntary association, and it's established as an initiative to advance the South African Constitution. And CASAC, like the LRC, comprises of progressive people from a range of sectors. And its advisory council and honorary members include former justices of the Constitutional Court, academics, vice chancellors of universities, etc. So it formed a good partnership with the LRC, whereby we had an institutional partner in this public interest litigation who represented its own constituency, but was also able to act in the public interest, which twinned with LRC's objectives in taking the instructions to litigate in this matter. And it was very good because the CASAC was able to, or it had the capacity to provide the LRC and to support the LRC with the reports, which were used as annexures, as very graphic annexures that actually showed how money was laundered across the world from the various banking jurisdictions from this project, and who benefited and to what extent. And these reports were actually placed in the public domain by Amabungane, which are journalists, activist journalists, and it detailed in comprehensive detail this corruption. So it was hard to understand the defense of the public protector claiming insufficient resources or inadequate powers to investigate. There was very little that she in fact had to investigate. Most of the work had been done. Our engagement in this case relied on attacking elite capture of land. It was important for us to get to the heart land redistribution projects that go awry in this fashion and then are swept under the carpet without any consequences. Because this frustrates one of the legal resources centers' strategic plans in contributing to the social discourse and to the attainment and achievement of equitable land redistribution and land reform in our country. So that was the context, because over 40 years, the LRC has litigated land or inequities in land from a range of perspectives. But now, in a democratic South Africa, where we ought to have a government that supports the constitutional goals of equitable land reform, it's very hard then not to mount legal challenges of this nature. They are expensive, they are long, and as we all know, raising the funds for such expensive litigation is not easy. And therefore, we have to be careful about how we use the money and in what cases we intervene. But I can say today that following this order of the Pretoria High Court and even the Public Protector's leave to appeal to the Supreme Court of Appeal and to the Constitutional Court, the LRC considers it a successful intervention, because on 28th of August 2020, the Constitutional Court dismissed the Public Protector's appeal with costs on the ground that it had no reasonable prospects of success. And the cost order that accompanied the LRC's declarator and review confirmed that she was required to pay, in her personal capacity, 7.5% of the CASAC's and DA's costs and 92.5% by her office. And this cost judgment held that as a matter of law, personal cost orders can be granted against public officials such as the Public Protector, where a gross disregard of their professional responsibilities has been proved, as we did in this case. So I'm going to go a little bit into the realm of politics now and to update you since this judgment. The current Public Protector is facing impeachment proceedings. And this Constitutional Court, or potential impeachment proceedings, and this Constitutional Court ruling posed another setback for the Public Protector's efforts to stave off Parliament's intention to formally inquire into her fitness for office. And it served to crush her hopes of appealing against the judgment that invalidated her report. And the full court found that her application for leave to appeal against the Pretoria High Court's judgment was actually it held absolutely no prospects of success. So since that Constitutional Court ruling, charges have been brought against the political high flyers in this project, and investigations continue today, and the capability to do that work has rested with the Zondo Commission on State Capture, and that information from the Zondo Commission is now accessible to the National Prosecuting Authority. And that is very significant because it gives hope and it tells us that there is a possibility that there may be consequences for what happened in this in the Estina Dairy project. So the picture has emerged, and we like to believe as the LRC and as CASAC that we helped and participated in a small way to help this picture to emerge and to prove where the 240 million rand that left the project actually went. And then it remains for public interest law centers such as the LRC. We remain, or we are left with the task of advancing and establishing jurisprudence for equitable access to land and for transparent and accountable land redistribution projects, by which we hope that interventions by civil society organizations such as the LRC, interventions that we are planning for the coming years, will in some way redress the pain and injustices visited on the dispossessed majority that we seek to represent in South Africa. So I think I'm going to stop there, and hopefully there will be some comments and some debate now. Thank you.
Thank you very much, Sharita. This was a wonderful presentation. Your passion and your anger regarding this case is completely clear to us. I think you made a wonderful overview of the political, legal, and social context of South Africa as a starting point to explain the importance of this case. Even though this case, I think you all agree with me, is of widespread corruption, which unfortunately happens more often than not in most of our countries. Without this historical context that you mentioned, you can't fully understand the extent of its severity. I think this case demonstrates the role also of civil society and journalism, which you said many times, to hold state officials accountable, but not necessarily the agencies that are created to seek transparency and accountability of the state, such as the public protector, which was the basis of this case. Also, I think this case demonstrates the importance of a strong high court or the judicial power, as it took the claims seriously and agreed with CASAC and LRC that the role of the public protector had failed in her constitutional duty to investigate the corruption issue. I think this case really has a widespread of issues, which is very interesting for all of us. So I think I'm going to turn to the audience, to the participants, if they have any questions. We have one question that someone made before. Is there any project for the National Population Register before the NRC in your country?
What is the NRC?
It's the final list of the citizen of a country. You mentioned this before at the very start.
Yes, yes. So we do have a national population register, but most of what shall I say, statutory or state requirements do not automatically require us to be classified. Yes, yes. So we do have a national population register, and it obviously documents as required. Yes. Erica, following on what you said earlier on in your commentary, what I wanted to say is that, what I wanted to point out is that we have just come from a period of extreme corruption and state capture that ran over a period of almost 12 years. And during that period, it was the courts and the media and journalists actually that remained the vanguard of the constitutional democracy. It's very important to understand this context and the time period within which the Estina project corruption was allowed to occur. It was a very dark period of our constitutional democracy, and one that we never thought that we would encounter in just 27 years. We thought it may happen later on, but not just so soon. And it was actually the extreme courage and the resilience of the courts and the immense courage of journalists actually that went to great lengths with civil societies across the world to actually gather the evidence in order to give rise to what is now the Zondo Commission on State Capture. And to think that something like that was allowed to happen within a constitutional framework within which we are supposed to function, I think was a severe awakening to South Africa to realize, as civil society, as public interest organizations, that we will never have the luxury of letting our guard down. Whether it was during colonialism, whether it is apartheid, or whether it is democratic institutions that conspire to actually derail constitutional imperatives in this manner. And we all know that in all our countries. And so, as I started off by saying that, notwithstanding the constraints that face us, it almost like remains our duty to go ahead, you know. And sometimes I think, like the public protector, we do not have the luxury of saying we do not have sufficient resources. And as public interest lawyers, in as much as we litigate, we also carry this burden that we, you know, within our organizations, to work efficiently and effectively so that we are in a position to sustain our work in ways that are creative and to plan strategically to use the resources that we do in as efficient a manner as possible. You know.
You actually responded a question that I had regarding the role of journalism in civil society, specifically how it's impacted corruption cases in general in South Africa, this civil society and journalism, this work that they have done. So you responded a question that I had. Let's see if anyone else has a question. If not, I have a series of questions that I would love to make. Does anyone have a question? Well, I'll go ahead and make a few questions, see if anyone else has a question. And I had a concern. Does this case has to do with the starting point is a public policy of land distribution. Has this corruption case changed in any way public policy of land distribution regarding land access? Has it made any impact in Free State or any other part of the country, obviously?
So this case, this Feeder Dairy Project case, together with other cases brought by other public interest organizations, has created a momentum, and it has actually forced civil society and other intended beneficiaries to interrogate the lack of a legislative framework for land redistribution in our country. And so the slogan has developed that you cannot redistribute land by policy, that there is a lacuna in our law, and that you actually need to put in supporting law or law that supports Section 25 of our Constitution, which mandates land redistribution following dispossession. So I would say that it has forced, the impact has been that the discourse and the debate amongst experts in land, amongst legal experts, and also amongst academics, but also at the grassroots level and community level, that actually we cannot allow our government, 27 years into democracy, to actually manage or administer what is an intrinsic issue for justice and reparation in our country through a series of policies. So within these next few years, litigation, strategic litigation and strategic interventions are actually being planned as programs to actually tackle such deficiencies in our law. So I cannot tell you that, oh, all of a sudden we have 10 successful redistribution projects or 5 million beneficiaries have successfully claimed land or have successfully received post-settlement support from the government. Unfortunately, I'm not able to do that. But what I can tell you is that cases such as this, or constitutional court orders and judgments such as this, have actually made civil society realize actually that the time has come, as I said earlier on, to take our cases to the Constitutional Court to establish jurisprudence. Because if the government is going to fail to do what it is required and how it is required to do that in terms of legislating, then the only option that remains to protect these rights in the Constitution is to challenge those failures. So yes, public interest organizations and civil society is gearing up for a period of land litigation, strategic land litigation. And so the stakeholders and there are interactions and there are engagements across many disciplines currently in the country, from forensic experts, from auditing experts, from statisticians to lawyers to sociologists, anthropologists, because we understand that just simple legal interventions or going just by relying on law is actually not going to suffice. Just as we did in this case, we need the forensic financial information to challenge and to actually not only corrupt redistribution projects, but also the government claims a lack of resources. So we are moving in the direction of interrogating government and the use of taxpayer money in projects that do not appear to address constitutional imperatives. In other words, we are trying to challenge this bias in favor of state-determined projects and not addressing the duty to address or to redress constitutional imperatives. Sorry, just give me one moment. I'm going to try and close my blinds so that you are not blinded by this afternoon sun, which is getting into my office. I see I have succeeded a little bit. Okay. Erica, are there any more questions?
Yes. Someone asked, and you've been mentioning this along your presentation, but more specifically, how in this case or in general have people raised their voice against corruption? You've mentioned strategic litigation. Obviously, this case is an important milestone for civil society to raise their voice and against corruption. How other avenues have civil society addressed corruption cases in your country?
So
to give us an example for our own litigation.
I wouldn't, yeah. I think what in South Africa, like in all our countries, how else have we shown our dissatisfaction or displeasure apart from strategic litigation is advocacy. Now, LRC was always employed lawyers. And as we all know, historically, lawyers don't want to hear about advocacy. They don't want to hear about lobbying. They don't want to hear about us making submissions, etc. Those were, the traditional public interest lawyering, what shall we say, methodologies that we were trained on. But more really, what we are finding is that stakeholder engagements and finding implementation partners that actually will be able to assist with the implementation and enforcement of court orders assists us a lot in actually ensuring that there is impact from legal interventions. And these may be non-legal civil society organizations. And this also supports broader mass action amongst the society and the, the general population. So for example, during this very dark period of state capture, which I mentioned and alluded to, many taxpayers actually withheld taxes. They withheld taxes, and the taxes that they would have paid to the South African Revenue Services were actually paid into special trust accounts until such time as the new president, Cyril Ramaphosa, was actually elected and came and assumed power. We also, as you know, like many of your countries, have very powerful trade union bodies. We have trade union bodies that use strikes And community, we call them community social services trusts, okay, where communities actually mobilize in support of cases that may be heard in court on a particular day or when a judgment is handed down. And this is a new way of working for the LRC. It's a departure from our traditional, very strict lawyering methods. And I must say it has brought much improved perspectives to how we work, to the partners that we bring into our litigation, like CASAC, like the other Chapter 9 institutions like the Commission on Gender Equality, the Human Rights Commission, the Rural Women's Movement, depending on what the issue is that we go to court on. I hope that answers the question a little bit.
I think this is so interesting what you mentioned about taxes, that some people refuse to pay taxes. I've never heard of that strategy. That's very interesting. I don't know if that would go well in many other countries, but that's a very interesting strategy. I would like to circle back to what you mentioned before regarding the need to have a legal structure because you said that it was a public policy for land distribution, but it has to be in the law. It can't be a public policy. And I'd like to circle back because I also gave a lecture a few weeks ago to these same lawyers regarding an indigenous land case that we have a judgment that we won before the Inter-American Court of Human Rights. It's the first case that the Inter-American Court decided on a land case or indigenous rights case in Argentina, where I work. And one of the main aspects of the case was the need to have a legal structure, to have legal norms regarding land. In this case, the recognition of indigenous lands, and in your case, land distribution, because it can't be a public policy, can't be just some decrees or some type of resolution, because it's not formal, it has to be in the law. And so it has to have a legal framework, but it also has this other aspect of advocacy, civil society, lawyers, non-lawyers, to hold accountable state officials in their work. So I think that aspects are so interesting, because I think this can be replicated in all of our countries. You need to have a legal framework to fight for a right, or for an action be binding and be correct, and also have a strong civil society, either organized or not organized, but to have people who can speak their mind and take action when something is not working right. And also, and I think it's interesting that in South Africa, you have the role of the public protector, which is, well, I've never heard of that role in Latin America. So I think that's a very interesting role. But what happens, and in this case, that's what happened, when such an important figure completely fails its job. And so it rests on journalists and civil society to take that role and to take that case to the high courts or to the public in general, because that role has failed. So I think that also has to do with what kind of person has that role. If there's any type of advocacy that must be done to have really great judges and people to take those highly important roles, to be like a public protector, and not any type of person can have that role, to have people that are really in the capacity to fulfill that role. And I think that's also very important, the role of civil society, to be very vigilant on who are taking those strategic spaces in the judicial power, executive power, and other powers in government. I think that has that's a very important role, and that's to all of our countries, not only South Africa, I can imagine.
Yes. No, Erica, I completely agree with you on your comments, and we have lived through that, like many of our countries. But I think the important thing to emphasize here is that the appointment of the public protector does have those checks and balances in place, in that there must be agreement of a majority of the National Assembly, of the person that is actually appointed to this post. But then it shows that, you know, notwithstanding all the checks and balances that one may seek to put in place, that we always have to remain alert, that we cannot ever believe that every person that is appointed to public office shares the constitutional goals and imperatives to the extent that is intended and expected of them. And I think that it's also important to point out that the courts were actually one of the remaining bastions of the safeguard during the period of state capture by the Zuma leadership. And that by withholding taxes, it was because even the revenue services in the country were captured during that period. That is how extensive and how quickly corruption can permeate any one of our democracies just within the space of 10 to 12 years and destroy and set us back actually so harshly that, you know, you actually have to really dig deep within yourself to actually maintain the momentum to continue the fight, not only as public interest lawyers, but as ordinary citizens who have suffered centuries of hardship and dispossession and oppression, you know. So, yeah. And that's why the tax bill, you mentioned it was so novel that tax was withheld. It was for that reason. The revenue service had been completely permeated by the Zuma era corrupt elements. Yeah.
We've talked about like a general political overview of this case and of historical situation of South Africa. And I have a very, very small and specific case. The farmers that were going to receive the cows and who are going to benefit from this project that didn't receive anything because of the corruption, did later they receive anything? Because at the end, they're the ones who lost everything.
Yes, so they were the reason. They were the reason why the LRC accepted that instruction to take that report and review. In as much as we wanted to challenge the public protector, in as much as we wanted to, litigate against her failures, but any public interest organization can do that. Any public interest law center to do that. But land reform and equitable land redistribution lies at the heart of the existence of the Legal Resources Center. And this straddles over 40 years of our existence. So yes, after we read about it, after we went there and spoke to them and met them and understood the sense of the betrayal, the extent of their ignorance of what was even meant to come to them. They didn't even know that. All they knew is that some person came and wrote down their names and personal details on a piece of paper and nothing else after that. So confronting the extent of that kind of brazen, what shall we say, disregard for such vulnerable groups. And these groups in this community actually were made up of widows, unemployed, pensioners, very, very vulnerable groups in what was a historically white province. The Free State is a white province. So obviously housing, land, educational opportunities have been not provided for such people in those regions for not only decades, but actually centuries. So the intergenerational poverty is very stark in such areas. And it was that which actually caused the LRC to actually enter the fray in these proceedings. Yeah.
I think that's the saddest part of this case, that they were their starting point. The whole objective of this public policy, which was very positive in some matters, was to give these people some more resources so they can have a better quality of life, and to try to eradicate in some way the historical discrimination they have suffered. And at the end, they received nothing. This huge case that unveiled so many things, that it's such a historical case, what was, as you mentioned, and a little bit that I researched on the internet with the Gupta leaks, and such a famous case, but the farmers still have nothing. And that's such a sad aspect of this case, that sometimes even with a wonderful judgment, a wonderful case, a wonderful litigation strategy, the victims still don't receive anything. That sometimes that happens. And I think it's frustrating also for those of us who litigate some cases, that at the end, the reason why you started litigating a case, even though you wanted to go more, you wanted to address corruption issues in general, but at the starting point, it was the victim. And at the end, nothing happened positively for the victim. I think that's sometimes frustrating for many of us lawyers, I think.
It is heartbreaking. It is frustrating, and it is heartbreaking. And it makes it difficult for you to measure or even claim a victory, actually. It feels a bit empty and hollow. But you know, as many of you know, the practice of public interest law requires you to really be almost all those qualities of the reasonable person, you know, that objective clinical person. And you sometimes have to see that actually the objective may not necessarily, or the goal or the result may not necessarily translate into tangible benefit for a particular community or client, but that it is used as a foundation or a stepping stone to develop jurisprudence in order to actually prevent or to demand accountability from successive redistribution projects. We would like to know that most recently there was actually another policy of state land lease disposal policy that seeks to almost redistribute 7,000 hectares of land. And we would hope, in fact, that communities such as the Feeder Dairy Project beneficiaries or intended beneficiaries would be prioritized in such policies to redistribute land. We don't know that because, as usual, it is cloaked in much, what shall we say, vagueness and inaccuracies. So it is hard for us to say as the LRC or as public interest lawyers that these specific beneficiaries will ever have their needs addressed or redressed in any future projects. I cannot make any claim to that. Yes. And it is sad. It does sadden me every time that I look at the case or I look at reports, and the only picture that is in my head is of the people that just didn't know anything about it.
That's the human aspect of these types of litigation, which is I face the same thing. I litigate at an international level to international courts, and it is sometimes we have a wonderful judgment that really is a milestone for further judgments, but the victim still didn't receive anything, didn't have any redress. If anyone else has a question, if not, I think we can end this session. This has been enlightening, has been wonderful, very, very interesting. Sharita, thank you so much for explaining and describing your experience, and this very specific corruption case can be very much translated to most of our countries in the world. Thank you so much, Sharita. I don't know if the center wants to say some words to finish the session.
Yes. Thank you so much, Sarita. This has been wonderful wonderful lecture. And thank you, Erica, for moderating it so wonderfully. Thank you all. Thank you to all the participants. We'll see you in the next lecture. Thank you all.
Thank you all for inviting me. It really was a pleasure.
It's a pleasure. It's a pleasure.
All right. Bye-bye.
Bye.
Thank you. Bye.